Hi there and welcome to this Tutor to You politics topic video taking a closer look at constitutional statute law. There are many sources of the UK Constitution: statute law, common law, conventions, authoritative works and treaties. The other four sources will be looked at in a separate topic video. Today we're just going to be focusing particularly on statute law, and we're going to be looking at a number of categories of statute law. For example, representation of the people acts, in other words, electoral systems, laws reform, devolution, rights and civil liberties. So let's start with a quick look at what we actually mean by statute law. So statute law really is an act of Parliament. An Act of Parliament is a bill that has worked its way through the Commons and nearly always the Lords, undergoing debates and amendments before finally being voted on and approved and becoming an Act of Parliament following royal assent. Statute law in the UK is the highest form of law. You can contrast that with the highest form of law in the United States, where there are indeed acts of Congress, but the highest form of law in the United States is in fact their constitution. That is not the case in the UK. Constitutional statute law is arguably more important than ordinary statute law, but it's not explicitly set out as a constitutional statute. And what constitutional statute law is, they are acts of Parliament that put into law some power or action of the government. We've got some general parliamentary statutes just noted down here for you. The House of Commons Disqualification Act of 1975 provides a little bit of clarity on which people cannot be MPs. For example, judges cannot be MPs, and that is in order to prevent too much power between the judiciary and the legislature. Civil servants and police constables are also regarded as not MP compatible. The House of Commons Disqualification Act also limited the number of ministers in the Commons to 95. Following on from that, also looking at the number of ministers and their powers, was the Ministerial and Other Salaries Act. So there can be up to 109 paid ministerial posts, but they cannot all be in the Commons. So for example, they could be external appointees or most likely from the House of Lords. This Act also sets out the pay for other key posts such as the Lord Chancellor, who formerly used to be head of the judiciary, and the Speaker of the Commons and the Lords. The Fixed Term Parliaments Act held that elections must be held every 5 years, and those would be at a predetermined date. There are exceptions in the case of a vote of no confidence in the government or a 2/3 majority vote by the Commons, as was the case in the 2017 general election, which was unscheduled and around 3 years earlier than we expected there to be a general election. We'll take a little look now at some of the Representation of the People Acts. Now, these acts effectively set out who can vote and how. So in 1969, the voting age was lowered from 21 to 18. And university students were allowed to then vote in their university town rather than having to be at home for an election. In 1983, election expenses were limited and candidates were limited to one free mail shot. This was an attempt to try and give third or minor parties a little bit more support and perhaps prevent some of the dominance of the Labour Party and the Conservative Party. Controversially, and still a huge source of debate today, is that the 1983 Act prevented prisoners from being able to vote. It also made it illegal to publish false statements about candidates' characters. In other words, people had to play nicely. In 1985, yet another act allowed British expats to vote in their old constituency for 5 years after they had left. That has now been updated to 15 years, and it introduced for the very first time postal voting. This was updated in a later act, but in the first instance it was just to allow a very select group of people to be able to vote by post. Those restrictions were removed in 2000, and the 2000 Act also required polling stations and candidates to provide additional assistance for disabled voters. The Electoral Administration Act of 2006 was very similar in intention to the Representation of the People Acts. The age of candidacy, in other words, the age at which you can apply to become an MP or try and become an MP, was lowered from 21 to 18. And for the first time, children would be allowed to accompany their adults, parents or guardians into polling stations and be with them when they voted. Furthermore, parties must declare large loans following the so-called cash for peerages or cash for honours scandal. Devolution is ongoing, and devolution has taken place through Acts of Parliament, through statute law. So if we look separately at Wales, Scotland and Northern Ireland, we can see that for all three there were reasonably significant changes in 1998. Now, the winning Labour Party manifesto of 1997 really set out a key election issue of the Blair, what would become the Blair government, in terms of encouraging devolution. This was very much a tribute to the former Labour leader John Smith, who had died in office. So we had the Government of Wales Act in 1998, the Scotland Act 1998 and the Northern Ireland Act in 1998. In Wales and Scotland there was a referendum that allowed those to take place. There have been, in all instances, further acts that actually either extend powers, sort out problems from the initial difficulties. For example, in Wales, the legislature and the executive were completely combined initially, and that was regarded as fairly problematic in terms of scrutiny. So the 2006 Act deliberately separated the two. More devolution topics and more depth is covered in our other topic videos. There is one for Wales, one for Scotland and one for Northern Ireland, so do take a look at those once you've watched this topic video. Lords reform, never too far away from the top of the debate pile in terms of the UK Constitution. Here we have some of the key constitutional statutes relating to Lords reform. The Parliament Acts 1911 and 1949 significantly reduced the power of the Lords. They were prevented from vetoing legislation, and instead they could merely delay legislation. The 1911 Act said the delay would be 2 years, and this was reduced actually by using the Parliament Act 1911 in 1949 to just 1 year. And the intention there was to prevent the Lords from stopping the nationalisation programme of that post-war Labour government. The Life Peerages Act in 1958 set out the fact that there could be women peers and that there would be no longer just hereditary peers in the House of Lords. You could be made a life peer. This was followed shortly by a 1963 Act in which hereditary peers who did not want to be in the Lords or did not want their title could renounce their title. That would then allow them to sit in the House of Commons. The House of Lords Act 1999, another key constitutional reform by Tony Blair's new Labour government. They reduced the number of hereditary peers to 92 via the Wetherill Agreement. And it also set out a replacement process for hereditary peers. So when their seat becomes available, perhaps through death, a replacement hereditary peer will be selected in a by-election, but the number of hereditary peers would remain at 92 rather than being run down. In terms of rights and civil liberties, again, many of these were introduced by the Blair government from 1997 onwards. The Human Rights Act 1998 incorporated the European Convention on Human Rights into UK law. It's worth noting that the European Convention on Human Rights is not actually an EU law. This is not part of our membership of the EU. So following Brexit, the European Convention on Human Rights will still be a key law that affects the UK. It makes it unlawful for any public sector body to act in a way that contravenes the European Convention on Human Rights. If judges believe that a UK statute law is incompatible with the Human Rights Act, then they will issue a declaration of incompatibility, but they do not have the power to directly override it. Remember that the UK Constitution allows for parliamentary sovereignty only. The Freedom of Information Act in 2001 granted the public the right to access any information held by them by the public sector. Whilst there was a financial limit, a cost limit imposed on that, it has been used by individuals, but certainly by media organisations looking for an interesting scoop and an interesting story. Ministers, if they feel there is an issue in terms of national security, are allowed to veto requests. The veto has only been used 5 times in its history. One example would be the so-called Prince Charles Spider memos, where Prince Charles wrote notes to try and influence decisions made by the government. Those have since been released as part of the Freedom of Information Act. The Civil Contingencies Act 2004 has certainly been one that has caused a huge amount of debate and has not been short of controversy. This act allows for any legislation in the UK, apart from the Human Rights Act and the Civil Contingencies Act itself, to be amended by a minister, not Parliament, in an emergency for up to 30 days. In other words, this grants the government whatever powers they might need to manage an emergency. This has been strongly criticised by some for trampling on rights, although the nod to including the HRA as one of the exceptions goes some way towards quelling that argument. Now, just some general constitutional statutes here that it's really worth knowing a little bit about in terms of examinations in A-level politics. Firstly, the Constitutional Reform Act 2005, one of the very few acts in Britain that actually specifically and explicitly refers to the Constitution. This act established the Supreme Court, meaning that the House of Lords was no longer the highest appellate or appeal court in the country. This goes some way towards increasing the separation of powers, separating the executive, the legislature, and the judiciary. The Supreme Court now, with its 12 justices, is directly opposite Westminster Palace, the Houses of Parliament in London, but is indeed a separate body. It also created the Judicial Appointments Commission, and that was intended to reduce what we call the politicisation of judicial appointments. In other words, politicians and perhaps the Prime Minister deciding who they would like, who might be a favourable judicial appointment, who might be interested in supporting the government's cause. That has now become much more neutral and has certainly helped to make the UK judiciary much more neutral and independent of government. The Constitutional Reform and Governance Act 2010, that required Parliament to ratify treaties, in other words, changing royal prerogative just a little, required appointments to the civil service to be made fairly and transparently, and exempted the royal family from freedom of information requests. The Succession to the Crown Act 2013 said that the eldest child, regardless of gender, can be in line to the throne. In other words, it is the firstborn, regardless of whether the firstborn is a boy or a girl. And it also ended the disqualification of acceding the throne to members of the royal family who were married to Catholics. So what lies in the future for UK constitutional statute law? Well, clearly the biggest thing on the radar at the moment must be the Great Repeal Bill, or to give it its correct title, the European Union Withdrawal Bill. This will repeal the European Communities Act of 1972, when the UK joined what was then called the European Communities, but became the European Union. It's intended to pass through Parliament in 2017 and 2018. And as part of this bill, all EU law will automatically be transferred to UK law in order to prevent a legal black hole. Any bits of that law that we choose not to have in the future can be repealed on a case-by-case, piece-by-piece basis. In terms of what else lies ahead, at the moment, the Great Repeal Bill is probably the most fundamental change to constitutional statute law, and indeed the broader UK constitution, that many of us will experience for some time. For more advice, guidance and support, and indeed more topic videos, do take a look at the Tutor2You website. Thanks for joining me.